Coming up on today's edition of Sunday Nation, in the new year, our conversation with federal bankruptcy judge Mark Randon of the Eastern District of Michigan. He's the only African-American U.S. bankruptcy judge in the state of Michigan. We're going to talk to him about bankruptcy, poverty, and what the court is looking forward to in 2023. And then, of course, our year in review, remembering the late Sidney Poitier, the first black man to win an Oscar, who belongs to a fading generation of African-Americans who exemplify resilience and black excellence. And of course, a reflection on my keynote address for Brown University's Black History Month in 2022. And of course, my take on Governor Gretchen Whitmer's second term, my analysis as the governor is being sworn today, all coming up on this week's edition of Sunday Nation, the first show of the new year. Stay with us. All right, let's welcome federal bankruptcy judge Mark Randon. He also happens to be the only African-American in the U.S. bankruptcy court here in the state of Michigan. Thank you so much for being here, and Happy New Year.
Bankole, thank you for having me.
Yes, it's a pleasure to have you. There's so much to talk about: bankruptcy, poverty, and of course, given the state of where our nation is right now. But I want to take you back to prior to 2023, COVID, its impact. We've looked at the impact, through the medical industry, health-wise, economy, but I think an underserved conversation, perhaps something that normally we don't hear about, is how COVID has impacted the bankruptcy court and moving forward where you see it. Let's begin before COVID. What was the bankruptcy court like? Well,
the trend had been going down for consumer and business bankruptcies.
Yeah.
They've been going down steadily since 2005. We expected a big increase during COVID,
right?
But because of the PPP loans for businesses, some of the stimulus checks, bankruptcies continued to drop right before COVID and through the COVID period.
So what did you see during COVID?
Well, one of the things that we ran into from a consumer standpoint is it was more important to have computer and internet access during COVID.
Yeah.
Because the court shut down in-person proceedings.
Yeah.
So if you didn't have access to Wi-Fi, to a computer, it made it very difficult to file bankruptcy.
Yeah.
That contributed, I think, to the declining numbers of bankruptcies during the COVID period.
Was it difficult for the bankruptcy court to transition to that digital, where you were having virtual hearings?
Thankfully, the court had put in place the ability for the judges and staff to work remotely.
Okay.
So it was a smooth transition for the court, not as much for the public who are used to coming in, doing in-person filings, particularly those individuals that don't have lawyers.
Right.
So it became a challenge for them.
Right. But was it a seamless transition for the court?
It was a seamless transition for the court. In fact, even today, Bankole, most of my hearings are remote now.
Really?
I probably spend 1 or 2 days a week at the courthouse. Most of the time, I'm at home doing my docket, either via phone or video conferencing.
So while other industries are debating whether to come back home, to come back to work, I'm hearing that a lot. A lot of industry, the judicial branch of government is already in that space.
Well, the district court across the street from the bankruptcy, they are back in person.
Okay.
But bankruptcy sort of lends itself to remote hearings because most of what we do does not involve debtors that are in bankruptcy. It's lawyers, status conference hearings, stuff that lends itself to be done remotely. We don't do that many trials.
I want to get into the anatomy of the court itself, because bankruptcy in itself is a very exclusive discipline. It's a very exclusive area of law, requires specialization to practice in bankruptcy court. Let's talk about that, though, how important that is.
Okay, so as you mentioned, bankruptcy is really a niche practice.
Right.
there are a small group, it's like a sort of a family group of lawyers that practice bankruptcy because it is so specialized. It's hard for a lawyer that doesn't have experience to break into bankruptcy because it requires working with a bankruptcy lawyer, interning with a bankruptcy judge, just to sort of get the background. So
it's almost like going back to law school.
It is. And so what tends to happen is practitioners tend to pass their knowledge down to people that work underneath them. And it becomes a very closed area of practice, which is hard to break in, which is unfortunate. And we're working to change that.
I mean, but what would you like to see, though?
Well, what happens is when you have a very closed practice that isn't very diverse, it's hard to get it to be diverse because it's hard for people from diverse backgrounds, people of color, to break into bankruptcy. One of the things that we're doing at the court, and I want to thank our Chief Judge Dan Opperman, is we've started an externship program where we're bringing in minority candidates from U of D Law School, U of M Law School, Wayne State, to come in, get some experience in the bankruptcy court so that they sort of have that access into the practice so that when they get out of law school, it's not an unfamiliar area to them.
So let me ask you this question then. In the wake of Detroit's 2014 bankruptcy and so forth, you are, in the space that you're in, did you see much interest in bankruptcy law?
There isn't, because I think people don't realize the important role that bankruptcy plays in all of our lives. I think
the 2014 bankruptcy for Detroit, I think, was a powerful introduction to bankruptcy for a lot of people.
It was. It's what I use in my class to broach the subject of bankruptcy and introduce the subject of bankruptcy to students.
So let's get into the question of granting relief to people. Where the courts, where your courtroom swarmed with a lot of people looking for help after COVID or during COVID?
Not as much as anticipated.
Okay.
Because, again, the government had sort of subsidized by providing stimulus packages and stuff, but that's all ended. There was also moratoriums on evictions and foreclosures that staved off the need for bankruptcy. That's all ended. So what we've seen in the past year, in 2022, was a slow but steady increase in the number of bankruptcies as people now find their debt loads increasing, interest rates going up, inflation, student loans.
And hangs in the balance,
So we are seeing now a slow but steady increase in number of personal bankruptcy filings.
So is it safe to say that you are going back to prior to where you were before COVID?
It is, yes. We are finally starting, the numbers are trending upwards, and the prediction is that they're going to continue to trend upwards for the next several years.
And this takes me to the subject, which is what I also want to talk about, and that is the nexus between bankruptcy and poverty. It's something that you've addressed when you spoke at the Pulse Institute Forum on bankruptcy and poverty. But given the state of where we are, in the nation, the economy, and of course, more and more people struggling, inequality is increasing, by the numbers and so forth. Does it become even more cumbersome for the bankruptcy court because you have to deal with people who are looking for reprieve or some sort of a relief?
Right. Thank you for bringing that up, Bankole. One of the big issues that we face here in Detroit, and frankly all over the country, is that those that need bankruptcy relief the most, the poorest in the community, have the most difficulty accessing the system. And the reason why is because the sad part is you need money to file bankruptcy. And particularly in personal bankruptcies, Chapter 7 bankruptcy, which is the best form of relief for most debtors, you have to pay your lawyer up front. And that can be between $1,000 and several $1,000s. Well, if you don't have the ability, if you don't have the funds to pay that money up front, then what you have to do is technically you go it alone, and the outcomes are not as good if you represent yourself in bankruptcy without the benefit of a lawyer. So that's something that the court has taken steps to address, but we really need to be vigilant about going forward, because what happens is we track the information. So we know the income level and the debt level of everybody that files bankruptcy. And we know that the outcomes for those that are at, below, or slightly above the poverty level in terms of getting the relief, which is a discharge. And what a discharge is basically it's where the debtor is no longer responsible to pay their debts. That is far harder to achieve at the lower incomes. And those people are the ones that need the relief the most.
So there's some interesting stuff at play here, because then the lawyers who are looking for their pay up front may have a different viewpoint to what you just said.
Right. The fact of the matter is if the lawyers would say that, well, if we don't get our money up front, then that service that we provide could also be something that the debtor discharges in bankruptcy.
Right, right.
So what we really need is beyond, I think, the court's ability to address. We need Congress to change the law.
But before we get to Congress, but how much leverage does a federal bankruptcy judge like yourself have in terms of being able to weigh in the need for these individuals who are coming to court seeking relief, not to be end up being more economically disadvantaged when they came in than before?
Yeah, and that's a reality because when a debtor comes in and can't pay their lawyer up front, which is what's required in a Chapter 7,
right, they
tend to file for a reorganization because you can pay your attorney over time.
Right.
But the Chapter 13 reorganization is a longer process,
much
tedious, more difficult to obtain a discharge. And if you get into a reorganization and you fail at the reorganization, you are in a much worse financial position you were than you started. But debtors don't see it that way because if you have creditors garnishing your wages, you're just looking for that to stop.
Yeah, momentary relief.
And any bankruptcy will do that.
Yeah.
But the choice of filing a reorganization as opposed to a liquidation, because you don't have the money to get a lawyer, can have very, very negative consequences long term. And so that's something that we have to address.
It's very interesting hear you articulate and outline it in this way, because I think sometimes people see bankruptcy as an economic salvation, you know, notwithstanding because I need my relief, momentary relief and so forth. But you're saying, you know, well, watch out, if you go this route, then there's a problem here.
Absolutely. Chapter 7 is typically the best for most debtors. There are exceptions.
Yeah.
But that requires, again,
right,
you to have money up front,
right,
or the services of a lawyer.
Right.
Chapter 13 is a payment over time,
right,
but yeah, it just comes with some very challenging consequences,
right,
because even though it does stop the
right,
creditors from trying to collect,
right,
if a case is dismissed, all the interest that was stayed during the bankruptcy
right,
comes back on,
right,
and so the debtor finds himself down to several $1,000s they put out to pay the lawyer.
Right, right.
Interest that's now been accumulating over 4 years that's now added onto the debt,
right,
and they're going to find themselves with the same garnishment, but now with far less money on hand to deal with.
So when you handle these cases, I'm curious though in terms of what do you see as a constant recurrence here in the cases that you handle as it relates to these cases that you just mentioned? You know, what's the constant recurrence here?
The constant recurrence is people that have credit card debt and medical expenses. And that comes from, you know...
Both of which are tied to poverty, though, by the way.
Both of which are tied to poverty.
Right.
And so what we see is, as now... And COVID really has played a role in this, because what we see is COVID sort of lends itself in the post-COVID era to people that have the type of job where they can work from home.
Yeah.
But most poor people don't have the types of jobs that allow them to work from home.
Yeah.
They're on the front lines.
Right.
They're your servers, your bus drivers, the people that collect your trash.
Yeah.
They have to be in person. And so they are still dealing with the same issues that require you to have transportation, daycare. Remember, these are all facts that can be ameliorated if you can work from home.
Yeah.
But that doesn't apply to most poor people.
Right.
And so the medical, the lack of health care, the credit card debt, student loans,
right,
and now what we're seeing with interest rates going up is that the debt that you have becomes that much more expensive to pay back. So these are reoccurring things that we see with consumer bankruptcies.
Yeah, remarkable. I want to talk about Congress and, of course, judicial diversity as well. But let's go to Congress, because you said some of these challenges arising out of the U.S. Bankruptcy Court in Detroit. Congress will have to provide answers to this. What are some of your concerns now? What would you like Congress to do here as a sitting judge?
Right. Well, first, the problem. The problem was in 2005.
Yeah.
Congress believed that too many people were filing bankruptcy.
Yeah.
We had about 2 million filings in the years leading up to 2005. So what?
2 million.
2 million individual personal
around
filings,
the country.
Around the country, nationwide.
That's significant.
It's very significant. And so Congress believed under pressure from the credit card interest and the credit card community and lenders, that they needed to make it more difficult for individuals to file bankruptcy. Now they targeted higher income people.
Right.
But it didn't work. The requirements they added in for credit counseling, for the means test, made it more expensive for people on the lower end to file bankruptcy. Right. So even though Congress has targeted higher income filers, what's happened is the number of higher income bankruptcy filers has stayed constant or increased, but the number of lower income filers that need the relief the most has decreased. So what needs to happen, I think? Okay. The first thing I think Congress can do is make it so that Chapter 7 attorney fees are not dischargeable in bankruptcy. That would mean that lawyers can say to their clients, look, you don't have to pay me all the money up front. You can pay me in installments in a Chapter 7. That would help out a lot. The other thing I think Congress needs to do is they need to take away some of the onerous rules that they put in place in 2005 to dissuade high-income filers from filing Chapter 7 that have had the opposite effect. For example, when you file a Chapter 7, you have to do pre-bankruptcy counseling. Sounds like a good idea. But in practice, it's a very sort of, how do I say it charitably? It's basically a waste of time and money. Mm-hmm. The consumer debtor gets very little out of it, and there's a cost of $50 to $100 for it. So it makes it even more expensive, and it makes it even more time consuming. Yeah. I think Congress could eliminate that requirement. They could eliminate the means test requirement that made it much more expensive to file bankruptcy. And they could change the payment of attorney fees to make it non-dischargeable in bankruptcy.
Interesting. Important recommendations for the coming Congress in January 2023. Before we end this conversation, judicial diversity on the bench, you being the only African American in the federal bankruptcy court in Michigan, is significant. And talk about judicial diversity here, because too often we don't see, African Americans on the federal bench in bankruptcy court, and it just behooves the mind to me that you're the only African American in the U.S. bankruptcy court in Michigan.
Right. I don't think there's ever been a time on the court where there's been more than one African American judge in the state of Michigan. The problem is, our bankruptcy court represents all of southeastern Michigan. Yeah. If you look at the stats, 35–40% of southeastern Michigan is made up of people of color. Right. And so when they come to court, for them, sometimes, usually never to see a person that looks like them, that reflects their community, sort of, it can breed distrust in the system. Yeah. The other thing it does is, again, because we have a closed system, for a long time, the only way an African American law clerk would get into the bankruptcy system was being hired by an African American judge. So right now, I have 2 law clerks. They happen to be African American. I have had non-African American law clerks. But it's a way to introduce more diversity into the system. Right. Something to note, we have a new judge, Judge Joel Applebaum, in the history of the bankruptcy court, which has been around before the 1850s, in the history of the bankruptcy court. Judge Applebaum, who
goes all the way to Reconstruction, but go ahead.
Right. Judge Applebaum, who just arrived within the last 4 years, is the first non-African American judge to hire an African American law clerk in the state of Michigan. So progress has been slow, too slow, but I want to commend my colleague for taking that step. And in fact, he's hired 2 or 3 now African American law clerks. Yeah.
You know, it's hearing this and hearing from you. I think that's why it's very critical to have the bench diverse, meaningfully diverse, with someone like yourself who brings impeccable credentials to this role.
Yeah, and the other thing is, I don't even think it's racial diversity. I think it's diversity in background, because when I was applying, I didn't have any bankruptcy experience. Right. So they asked me, what's your experience? I said, well, I've been poor. Right. And I think growing up poor and having people from diverse, even financial backgrounds, it gives a judge a sort of sensitivity to debtors, that in those areas where we do have discretion, we can be more sensitive to the needs of debtors, particularly if we've come from that background.
Do you feel that message sometimes, that need, what you just said, is underappreciated?
I do, because so many times, if we pick judges from a very closed, set of background,
yeah.
we not only don't get the benefit of sharing insights with our colleagues, but I think it hurts. I think it hurts those people that we're there to serve, which is people that come in that need relief. Because I think debtors need some degree of sensitivity to their circumstances, to what they've experienced. And to have, I don't think every judge needs to come from sort of difficult circumstances. But it helps to have that in the pool. So as we have these discussions in court on how to shape policy, diverse ideas can be brought to the table.
Finally, as we look into 2023, this is a new year now, I can imagine your docket is increasing, it's getting filled up.
It is increasing. On the corporate side, Bankole, small businesses are having big difficulty, and we're seeing a significant increase in the number of small business bankruptcies. There have been supply chain issues, obviously borrowing money has gotten more expensive, and so we're seeing a lot of small businesses in this area have financial difficulties, and of course that trickles down to our residents who work for these small businesses. So yes, the docket is increasing, but we're excited to sort of have a role in helping these businesses reorganize, stay in business, and continue to employ people.
Well, I wish you good luck. I don't begrudge your role. I think your plate is full, clearly, as you laid out here, and the court is very important, especially bankruptcy court, in all of our lives. Thank you so much for being here.
Bankole, thank you for having me.
All right. As the eminent federal bankruptcy judge, Mark Randon from the Eastern District here in Michigan, the only African-American judge in the U.S. District Court in the state of Michigan. We'll be right back with more on Sunday Nation. Stay with us.